Will a trust avoid probate? Attorney Christopher Hayner explains. If a trust is a standalone trust, such as a Medicaid Asset Protection Trust, yes, the trust can be utilized to help a client avoid probate. If, however, the trust is a testamentary trust, probate cannot be avoided and, in fact, is required before the trust is even effective. Even with a standalone trust, the trust can only allow a client to avoid probate if the trust is appropriately funded and the client ensures he or she has beneficiary designations on all accounts and assets that are not transferred into the trust. I hear from a lot of clients that they are bombarded with calls to create a trust to avoid probate. While this may be a goal of the client, it must be explored why the client wishes to avoid probate. In New York, the probate process is not overly burdensome, so if avoiding probate is not the primary goal, clients may be surprised to hear knowledgeable estate planning attorneys actually recommending an estate plan that includes the creation of a last will and testament and, eventually, probate. There are two primary instances when I usually recommend avoidance of probate. The first is when the client owns real estate in multiple states, which requires having the client's will admitted to probate in every state in which the client owns real estate. The second is when the client has a particularly litigious son or daughter who will do all he or she can do to make the probate difficult and expensive. The above being said, I think it's important to explain how a standalone trust avoids probate. All trusts, including standalone trust, contain provisions that say their trust assets pass after the creator or client's death. Therefore, any asset transferred into the trust by the creator or client will pass pursuant to the trust terms, without the need for probate. However, with most standalone trusts, clients typically do not transfer all assets into the trust, and in order to collect the assets outside the trust, probate may be needed. In addition, because clients want flexibility when creating a trust, especially a Medicaid Asset Protection Trust, a provision is typically included in the trust that says that the creator or client can change the distributions provisions of the trust by writing a last will and testament, especially for the purpose of changing trust beneficiaries, and, of course, this will must be admitted to probate to effectuate the desired change. Call now for a personalized evaluation or visit his website at www.chaynerlaw.com.